even you, Mr. Blisle, this was a very serious matter. And it rose to a level of violence. Maybe that's in your nature, maybe that's not in your nature. I don't know you again from Adam. This is the first time I've seen you. You're from Osceola, you're from a different county, but from your criminal history, which is very sparse, it appears that you follow the law, or you usually do what you need to do, and or you haven't gotten caught. But if it relates to violent episodes, other than the ones that were from 08 or 10 or whatever those are, Mr. Schmidt. All right, I have a Kevin from Selmella. What case are you here for? I can't hear you.
It's operating well for them.
Okay, are you on my calendar today?
I believe so.
And what's your last name?
Salmala?
Salmala. I'm not seeing it.
Oh yeah, he is at 10 o'clock. Kevin Cleve Solomon.
Oh, okay. Oh, Adam. Oh, with Adam Nero. You're really, really early. You are so allowed to wait here for a half an hour, or you can try and call in early. I'm going to guess that Mr. Nero said, you better try and make sure that it works.
Right.
So you can either hang out here for a half an hour, or you can call back or punch back in closer to 10, okay?
Okay, thank you.
All right, thank you. All right, thank you. We will go on the record in the matter 25 CF 167, State of Wisconsin versus Alan Blisle Jr. This date appears through District Attorney Kevin Schmidt in person. We have Mr. Blisle in person with his counsel, Michael Becker. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Becker, can you please recite it on the record?
Your Honor, Mr. Blisle is going to enter a plea on count 1 and count 2. The parties are jointly recommending that Your Honor withhold the judgment of conviction as it relates to count 1 and approve of the DJOC document that is attached to the plea questionnaire. It is for a period of 12 months. It has affirmative requirements, obviously commit no new crimes, but to complete an AODA assessment by a state certified provider, and do so within 90 days, and to obviously inherent with that, remain on bond. He has certain bond conditions related to sobriety, absolute sobriety. As to count 2, the parties are jointly asking this court to order 10 days of jail. And I'm going to ask the court to allow 60 days for him to report on that. I will note he'll, I think, end up doing it before the end of this month due to work reasons, but just asking for that grace period. Counts 3 and 4 to be dismissed with prejudice. And the only other thing is to have restitution remain open at this time. There has been a restitution request made. I've received some documentation. Attorney Schmidt and I have discussed that. He's attempting to get more documentation from the victim. If it all pans out, I don't see an issue as to the amount. We're just looking to verify that amount. That's all.
Victims' rights compliance?
Yes.
Is victim going to make a statement here today? No. All right. Okay, so I'm willing to hold open restitution for a period of time. 30 days enough, or do you need more?
I'm confident getting done way less than that.
Okay, I'll hold it open for 30 days. If I don't hear anything other than getting an order to sign for stipulated restitution, then I am going to, and we won't have restitution because I'm only holding it open for 30 days and I'm not going to set a hearing.
Understood.
But if we are going to need to have a hearing, just let the court know and we can get that scheduled. All right. So I have in front of me a plea questionnaire waiver of rights form, as well as a deferred judgment of conviction document. Did your attorney go over these documents with you?
Yes.
Did he go over them thoroughly with you?
Yes.
Did he essentially go over them word for word?
Yes.
And do you understand everything completely?
Yes.
If you didn't understand something, did you ask him to explain it?
Yes.
And he did so.
Correct.
Did you sign both of these documents?
Yes.
So you are pleading guilty to 2 counts. One is a felony count, strangulation and suffocation, and one is a misdemeanor battery. Is that correct?
Yes.
You're 44 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or medications in the last 24 hours. No mental illnesses or disorders, correct?
Yes.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney thoroughly go over with you the maximum possible penalties you face?
Yes.
Attached with both of those documents are the jury instructions for the crimes. And he thoroughly went over those with you?
Yes.
So you understand everything completely.
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on both of those documents on the first page. Did he thoroughly go over those rights with you?
Yes.
And do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand? So you understand those rights, but do you need me to go over those rights with you in any more detail?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Now, do you understand that if the court does accept the deferred judgment of conviction, the next requirements will not go into effect, and they won't go into effect unless the court enters judgment either through this deferred judgment of conviction or today. So do you understand that you're charged with a felony, and if judgment is entered, you would no longer be able to possess or own a firearm?
Yes.
You would no longer be able to vote in any election until your civil rights are restored.
Yes.
Now, here, the state would have to prove for count 1, strangulation and suffocation, on or around November 23rd, 2025, in Burnett County, Wisconsin. You intentionally impeded the normal breathing by applying pressure on the throat or neck of another person. Do you understand what the state would have to prove?
Yes.
Do you understand for that Class H felony that upon conviction, you could face a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes.
As to count 2, misdemeanor battery, the state would have to prove the same date, the same time, the same place. You caused bodily harm to NS by an act done with intent to cause bodily harm to that person without that person's consent. Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
Now, your attorney placed the agreement reached with the state on the record. Do you understand that agreement as it's been reached?
Yes.
Do you understand that I'm not bound to follow that agreement? That means I could sentence you all the way up to the maximum possible penalties for both of these crimes, and I'm not required to accept a deferred judgment of conviction. Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
Did you go over that criminal complaint with your attorney, and in particular, a section called the probable cause section, where it basically says what happened that day and why you were charged with these crimes?
Yes.
For the most part, and I do understand that alcohol was an issue or involved here, but for the most part, are you admitting that the facts are accurate?
Yes.
Mr. Becker, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, as well as the preliminary hearing that was conducted.
Thank you. Are you pleading guilty to these crimes, Mr. Belial, because you are guilty of these crimes?
Yes.
All right. Now, has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the discovery and the evidence and discussed it with you?
Yes.
Have you discussed the facts that you know to exist with your attorney?
Yes.
Has he discussed with you a potential for any legal defenses or a lack of defenses?
Yes.
Have you discussed with him, again, any defenses that you believe could exist?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to count 1, strangulation, suffocation, a class H felony, how do you wish to plead?
Guilty.
As to count 2, misdemeanor battery, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those counts. The remaining counts and any open matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered as to count 2. As to count 1, the court will allow parties to be heard. Mr. Schmidt, we are in victims' rights compliance, no victim impact statement to be made here today. So argument and sentencing recommendation.
Judge Alan Belisle is a 44-year-old man with no prior criminal convictions. The only criminal history he has is in 2008 and 2010. He had DCs in Burnett. One was not violent. The other seemed to be a reciprocal event with a significant other, where reading the criminal complaint seems the other person initiated it. In this case, this happened many years later. In these circumstances, you can see the level of intoxication of Mr. Belisle on the body cam. He was in a woman's room on her bed, and the officers took a great deal of time to even convince him he wasn't in his room in his house. That's the level of intoxication. He couldn't really stand or walk. It was troublesome getting him down the stairs at all. In Wisconsin, thankfully, we're a state where intoxication can't be a defense to criminal culpability, but it's incredibly relevant when figuring out the sentence, how to prevent it in the future, how to protect the public, how to make sure it doesn't happen again. That is why I've structured this as it is. The DJOC has the AODA requirement. That's 100% what's needed in this case. I think there's no doubt about it. This isn't a domestic incident. The victim doesn't even really know Mr. Belisle that well. She was just giving a friend of a friend a place to stay when he was clearly extremely intoxicated. There was no inciting incident. Essentially, he was there sleeping. He was so intoxicated, he got up, started hitting the wall. She told him to stop. He stopped once, did it again, came back. That's when he choked her. That's when he attacked her. The reason why we're still getting the conviction and doing the 10 days jail on this is because the way this impacted the victim is so severe. It's just necessary in this case. It's necessary that this be the first conviction for Mr. Belisle. It's necessary there's some incarceration. The reason she's not here today isn't because she doesn't care about the outcome of this case or didn't impact her enough to give a statement. It's because it impacted her so much. I won't go into the details, but she's affected emotionally and psychologically a great deal and still is to this day. That's what I'll leave it to on that. So I think that this accomplishes all the purposes of sentencing. I think that this accomplishes punishment with the jail sentence and not depreciating the seriousness of that with the jail sentence in conjunction with the conviction, the first conviction he has. So going forward, somebody asks if you ever convicted of the crime, the answer is now yes. And then also the DGOC making sure that we accomplish the rehabilitation and public protection objectives by making sure this doesn't happen again. It was obviously caused by alcohol. He had no motive to attack her at all. So I'd ask the court to follow this agreement. Thank you.
Is that why restitution is, one reason why restitution is being held open? Is she seeking any kind of trauma services?
No, the restitution is immediately after this. She was affected so much emotionally, she couldn't go to work for the week afterwards.
And that was around Thanksgiving, if I'm recalling
Yep.
correctly.
So she gave us the time card, which shows the time they did pay, but we need the work schedule to show she was actually scheduled to work there. So I didn't realize that until Mr. Becker emailed me, and it was too late to get that from her today.
How, in the state's view, will Mr. Becker have the oversight to control his alcohol intake with the DGOC?
Mr. Belisle,
Oh, sorry. I'm sorry,
You're
Mr. Becker.
Totally good. Just wanted to
BBs.
make that clear.
No, I'm
100%.
totally okay with your alcohol intoxication, but Mr. Belisle, I'm sorry. With the deferred judgment of conviction, what oversight is there going to be to ensure that he is not only getting that AODA assessment, but that he's controlling his level of
Well,
intoxication?
the AODA assessment, there's benchmarks in the DGOC by when he has to do the assessment and do the treatment, provide proof to us. So if he doesn't do that, I mean, it's on him to prove that to us. So that would trigger a filing of a motion to revoke the deferred judgment conviction. If you're asking if there's any testing built into it, there isn't anything like that, no.
All right. And is there absolute sobriety in the deferred judgment?
I believe it's a condition of bond. So I didn't put it as that.
All right. I'm going to pull up bond. There is an absolute sobriety condition. There would have been in that he would still be under bond for a period of 12 months. So, all right. Mr. Becker.
Thank you, Your Honor. I agree largely with the context and the things that DA Schmidt has said. Mr. Belisle is 44 years old. He works for Zeman Construction as a field superintendent, so he's employed full-time gainfully. He supervises construction projects, loose term, in the Twin Cities metro area predominantly, but it spans on this side of the river sometimes too. As DA Schmidt indicated, he has no prior criminal record. There are the two things that are quite dated, 08 and 2010, which didn't result in any criminal convictions. The incident here is outlined in the complaint as reflected in the body cam. There's no question that alcohol was at play. In addition to that, Mr. Belisle was taking a medication in a new dosage, and so there was a mixture that he hadn't experienced before.
What medication? There was nothing listed on the plea questionnaire.
At the time, not now.
Not now?
He's not taking it now. No. And it wasn't for a mental health issue or anything like that. But I believe because of the dosage and the amount of alcohol that was present, there was an interaction which he hadn't experienced before. As a threshold issue, the amount of alcohol present was high in and of itself, right? And so obviously not an excuse by any means, just factually what happened here. The facts as they exist, which led to what happened. The agreement that's been structured, the agreement that he's accepted, has him taking responsibility for his actions that night at the most severe charge that he's charged with and at the second most severe charge that he's charged with. I think it is a measured agreement in terms of what is required of him. I have always described DGOCs as probation light to people. It's the same thing. You have conditions you have to follow. If you don't follow them, you get in trouble. That's what happens on probation. The difference here is you're betting on yourself. You have something at stake, and that is not being a convicted felon, which is a high benchmark for somebody who today, as he sits here, is getting his very first criminal conviction on a misdemeanor battery. And so Mr. Belisle is betting on himself to be successful, to do what he needs to do in order to demonstrate to the DA's office and to this court that he is a quote unquote healthy and productive member of society, and that what was outlined in this complaint as of happening November 23rd, 2025 is not his normal, nor nowhere near his normal. It's an anomaly, a big one at that, a severe one at that. No one discredits that. No one argues that. I think pairing the DGOC with 10 days jail is the carrot and the stick, right? Case law tells us that probation is the first thing that you look at. That's why I referenced the DGOC being probation light. We can call that good right there on the DGOC. And then we're looking the next step further on the jail, right? It demonstrates to Mr. Belisle what happens if you're not successful. Because if he's not successful on the DGOC, he's likely, the state will do what the state needs to do. He comes back in front of this court for a sentencing hearing where anything is fair game, probation, jail, or prison. It's all there. And as a former ADA, now defense attorney, I've seen many of those. And we can all agree that probation is a tough sell on the revocation of a DJOC. It's not impossible, but it's a tougher sell. So the jail is kind of a warning shot across the bow, so to speak. Overall, I think this is an appropriate resolution when we look at the facts and the circumstances. This incident clearly demonstrates through the videos and the testimony, Mr. Belisle was not in a headspace where he was interpreting things appropriately or positively or accurately. He was not the most cooperative person in the world with law enforcement. It's because of how intoxicated he was. Again, that's not going to fly to 12 members of this community, but that's the underlying issue. So we addressed that through the AODA, and that will hold him responsible. I did forget to mention this off the top, and I apologize. And it goes to the conversation we've been having about bond. I 100% agree that the absolute sobriety condition should exist. We do not argue that should come off. I only wanted to discuss the following condition, that he can't go to any bars, taverns, or pubs. One, from a work perspective, he may have to work in those areas through his construction job. And two, he runs a volleyball league in the summers at Wood Hill Bar and Grill out of Osceola. He'd like to keep doing that. He plays in it. He runs it from a logistics standpoint. Now, the interplay of that is, we understand alcohol is an underlying issue of what happened here. He understands that by making this request to the court, he's basically putting the court and the DA's office on notice that if you grant that request, he's going to be at that bar and grill for this volleyball league. So,
or he misses it for a year.
That too. I just mean if you grant it. People's instincts are up. They know what he's doing. There might be more oversight as it relates to that, right? And so he's confident in his ability to withstand any pressures or any inclinations. Also with an AODA and whatever treatment comes with that will help him through that to be sober, stay sober. And so that is another request that we wanted to make from that aspect. But overall, that is my argument, Your Honor. I'd ask that you adopt the joint recommendation, as I believe it's appropriate and measured here.
Thank you. Can you repeat what he does for work? Because you said he goes on the other side of the river.
He's a field superintendent for a construction company. So I think we can liken it to a project manager, foreman type. He's overseeing these jobs.
He's the boss.
Yes.
On site. Yes.
Okay. So you're not doing the construction unless you're showing him how to do it.
Yes.
Okay. If you have an ability to be somewhat flexible in your job?
My understanding, and he can verify, is that he's assigned job duties or locations to do projects. He doesn't get to do the assigning of the ones he goes on.
No, okay. But if do you have a flexible week where you could say, I'm going to be honest, I'm going to be telling you, I'm contemplating adding a requirement to the deferred judgment of conviction to do one of our restorative justice programs, because I think it will help you, not only with what happened, but it will help you for the future with the unknown that the court has. Because I don't know you. This is the first time I ever met you. First time you've been in court. I don't know if you do have an alcohol issue or a substance abuse issue. I don't know any of those things. You do, or maybe you don't, because you've not been able to totally self-reflect. And so that was my thought, because I think you would get a lot out of it. I think you would really like our restorative justice coach, Dave Hatch. He's great. He's great in a whole lot of other things, and he can help you, or you might just like him and learn a lot. And so that's what I'm wondering. Do you have the ability to be flexible? It would be for a period of 4 weeks. And so I'm not sure your work hours, your work schedule, those kinds of things.
I guess I don't understand where I can leave work early, or I guess.
Right.
Not.
Or leave work early, or be able to go in late one day or something of that nature.
Yeah, there's some flexibility there. It would just kind of depend on what job I'm on at the time and what state of the project we're in, there's times you have to be there for inspections and meetings with
right. And
clients and stuff.
It would be something you would work out with Mr. Hatch of when you're able to fit it in and to do it. And he does travel some too.
Okay.
So you can meet halfway.
Yeah, I guess.
Or something. Okay. All right. Mr. Schmidt, as it relates to anything stated with the bond modification request?
As it relates to what they're saying, no.
Okay. All right. Mr. Belial, anything you want to let me know, you want to tell me, or was there anything else you wanted to say, Mr. Becker?
I think I said my piece. Thank you.
Okay, Mr. Belial.
Just that I apologize to both Nicole and the sheriff department on my behavior that day. It was, again, not like me. Just honestly completely embarrassed about it. I have no doubt in my mind that if you adopt the JOC and this plea deal, that I will complete it 100%. That is no question in my mind. That's just too much to lose if I don't. And yeah, I just apologize to everybody involved about the whole thing.
So, Mr. Belial, prior to this incident, would you say that you had some issues with alcohol? Let's be fair. I know a lot of construction people, and I know that some of them like to partake.
A problem? Honestly, no. I don't drink if I have to work the next day. I only have some socially on the weekends. No, but it's not hard for it to spiral out of control on a given night.
It could spiral out of control?
It wouldn't take much.
Okay.
Not that it's happening often, but
Okay, sorry, I'm just writing something. Anything else you want me to know?
not at this time.
All right, thank you. What I get to know about the case is what is in the criminal complaint and what the individuals tell me, or what impact statement I hear from any victims involved. So what I have in front of me is simply what's stated in black and white in the criminal complaint, again with the arguments. I think everybody here admits, even you, Mr. Belial, this was a very serious matter. And it rose to a level of violence. Maybe that's in your nature, maybe that's not in your nature. I don't know you, again, from Adam. This is the first time I've seen you. You're from Osceola, you're from a different county, but from your criminal history, which is very sparse, it appears that you follow the law, or you usually do what you need to do, and or you haven't gotten caught. But if it relates to violent episodes, other than the ones that were from 08 or 10 or whatever those are, Mr. Schmidt, the state's not even saying that they were extremely serious. There's something to be concerned about. This looks like it could be a pattern, and it could be hidden from 2010 to 2026. So I'm not getting that as an argument from the state. I could be, but I'm not. So I'm not going to define anyone who's in the contract or construction business. I know plenty of people, family members of mine are, but I do know that sometimes after a job or after a night, and especially if you're out of town and your house out of town, generally people go and they have a few beers or they have a few more. I don't know if you do have an alcohol issue. You did make a statement that at times you could, I don't remember your exact words, it can get out of control or get out of hand. Thankfully, it has not gotten out of hand to this level before. Otherwise, this would be a different outcome. But again, this is a serious matter. It's so serious, and it was so impactful to the victim that she can't even appear here today. for fear, I'm guessing that it would cause her anxiety to go up, all of these emotions, just from hearing what's going on and probably from the sight of you. That makes this extremely serious, and that makes the court have to look at this a little bit more carefully. You are accepting responsibility and you are willing to be accountable. This is a crime. You're 44 years old, and now you are a convicted person. You have a criminal record. You can't get this expunged off of your record. It will be there, and it will be there as a battery on your record. There are certain requirements in the deferred judgment of conviction, and that is an additional oversight. It's not as stringent as probation. There's pluses and minuses to deferred judgment of convictions because they are serious enough and they do have enough oversight that if you do not abide by your bond conditions and or you commit any crime that rises to the level of probable cause, or you do not do your AODA assessment and provide proof to the state, and or you don't pay your $150 within 60 days, a felony can be entered on your criminal record. It could be the agreement can be revoked and terminated, and judgment will be entered, and you will be in front of the court for sentencing on a felony, and you will be a convicted felon. That's what makes this a little bit more of a stick over your head, because I think I'm gonna guess. I don't know. You like to hunt.
Yes.
Yes. And it would be a serious penalty to you to have your firearms taken from you forever.
Yes.
And so knowing that and knowing that you are under your bond conditions, hopefully that's enough for you to abide by the law and do the things that you need to do and follow the law to the letter instead of walking that gray line. Because not only will you lose your firearms, you're going to be a convicted felon. You could go to prison because it's a Class H felon. Serious. Now, for the most part, I do think that the agreement is appropriate. There's going to be punishment with jail. Nobody likes to go to jail, especially an individual who, other than these 2 days, I don't know if you've ever been in jail, but that's going to be the longest time that you're going to be in jail, hopefully for the rest of your life. That's punishment enough. You can't order Diet Coke. You can't order a steak. You're stuck with whatever food they have and they give you and the packet of lemonade. Okay? So that's not going to be fun. And I believe that will give you time to reflect even more on this incident and what happened. I'm going to accept the deferred judgment of conviction because it is something that is serious and you could be a convicted felon if you don't abide by those things. I am adding the condition though, and I'm going to write it right on there, that you do the apology letter coaching, and you write an apology letter, whether or not she wants to receive it, because she has the choice where she doesn't even have to even open the envelope and read it. That could be traumatizing for her. But at least there, if that happens, she would be able to hear your remorse and anything that you want to say and apologize. So I'm going to say that you do the apology letter coaching with restorative justice. And at the same time, you do the skills directed practice. The skills directed practice, that's where you can meet with Mr. Hatch and he can talk to you about any resolution skills that you have, cognitive awareness, thinking before you act, and possibly thinking before you have the third beer or fourth beer, or even the first beer, quite honestly. And it is a program that will restore your relationships. You'll get an idea or understand the impact of the victim, and you'll be able to think a little bit more about that. And it's there so you can have a better understanding, so that you can, when not extremely intoxicated, you can respond to things that happen in your life instead of reacting. And I asked your flexibility with work because this is a 4-week program, and the apology letter coaching can be built right into that. But I am going to say that Mr. Hatch can be a little bit more flexible, and that you can work it out. So even if it takes 8 weeks, it takes 8 weeks. The important thing is that you do the class, you learn the things, you speak with Mr. Hatch, who is a previous probation officer for over 20 years, and now all he does is restorative justice, which is trying to restore. It does a whole lot of good things for the community, for people who are in your seat, as well as for victims. And so I love the restorative justice program, and Mr. Hatch is really good at what he does. And I think you're going to find him to be a really good person. And you can probably talk to him about a lot of life things. So I'm going to say that that needs to be completed. If this is going to be a year, I'm going to say within 5 months. But you do have to contact Mr. Hatch. Today is Wednesday, and at least leave a message for him by the end of the week and have him try and connect. And you can talk to him and you can say the court said this can be flexible, but he's going to get my document that says be flexible. You're going to get a copy of this too. So by August 31st. So I am accepting the deferred judgment of conviction. Again, I'm going to strongly encourage that you pay the $150 to the state immediately if you can, because that is the number one reason I see the state asking me to enter judgment and to sentence on that felony. Okay, so take care of that right away. As it relates to the battery, I will sentence you to 10 days of jail, 2 days of jail credit, $500 in fines, fees, and DNA surcharges. I am going to hold open restitution for 30 days to wait to see what that amount would be. If it's stipulated, then I'll get a stipulation to sign. If it is not stipulated, I will hear if we need to have a hearing. Okay, and you'll be notified by your attorney. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Again, if the deferred judgment of conviction is entered and you are sentenced on that, you will no longer be able to use or possess a firearm for life. Bond conditions still exist and they are still in place. However, I will modify bond to state that with any bars, taverns, liquor stores, casinos, as long as you can be there for a work-related purpose. Obviously, you're going to be fixing it up. You're not going to be staying there 8 hours during the day, or it shouldn't be there at night. So it should only be during the day. And as it relates to your volleyball, I do think that that's a positive thing. Granted, I know I've been on a bar league before. Sometimes it can be overly fun, but you are on a no drink. So you can do the volleyball league, but there's absolutely no alcohol, and I'm letting you know you can be tested. And if anyone sees you or thinks that you're drinking, they have the ability to call the police because that's a bond condition. They can come and they have the right to test you. Okay? So they will test you right then and there. And if you violate, then that means you will be arrested immediately and the deferred judgment of conviction will be entered. Okay, so it's very important you follow that, and don't even go like I'm at home, so that means I can have a drink. No one's going to know, because then that opens up in your brain where you're like, well, maybe one drink at the bar is fine or at the volleyball is fine. No one's going to know. They'll think it's iced tea.
Yep.
Okay.
Yep.
20 days to appeal. I stated that. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, You're always going to owe it. I will issue a warrant and you can sit up to 6 months in jail. We have $500, so that could pay your fines and fees, but quite honestly, that's going to first go to restitution. Because the money always goes first to restitution. You're going to have to pay off that restitution and or pay off all your fines and fees, because I'm going to tell you, I don't know if you sat through the one probation review hearing I had, but I have restitution court. You will be in front of me. I have the ability and I have tools at my hand, and you could sit jail. So it's very important that you understand that and you pay. And the same thing with the court costs and fees. I need your DNA. You're going to need to go to the jail and provide that. If they have it, they'll send you on your way. If they don't, they'll quickly swab you. With the battery, you have the ability to request it be expunged through a written letter to the Department of Justice, not to me or this court, to the Department of Justice. It's easy to do. And I don't know if Mr. Becker knows how, but it's easy to do. You can Google it and very easy instructions. So either you can Google it and figure it out, or Mr. Becker can, and you guys can talk about it. But it's easy to do. With the felony, that just kind of hangs out there. And if you are convicted on the felony and I do sentence you, I'll tell you the same thing. Do you need me to go over your bond conditions with you again, or do you understand them and as they're modified?
I understand.
Okay. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Becker?
I don't think anything, Judge.
I am missing one thing. With the report date, did you ask for 30 days or 45?
I asked for 60. I am confident he's going to end up doing it in about 2 weeks, given work scheduling, but I just asked for
Okay.
time. So.
I don't know about other judges, but I never give the 60 because you never know what's going to happen and you may need to extend it. So I will give 45 days to report that. And then you will come here, you will report to the jail. I'm going to strongly encourage that before you report, you give the jail a couple days notice. We have enough room, we have enough things, but just make sure they have enough staff on. Because one more could mean that they need one more staff. Did I miss anything? All right, we're good to go. We are adjourned.
Thank you, Judge.
I just have to.
That's okay. And you're going to need copies of these. Okay.
If you want to meet at window, I think it's family, we'll get you signed and copies of that. I'll be right back.
In a final ruling, 44-year-old Alan Balalel Jr. pleaded guilty to felony strangulation and misdemeanor battery. While the judge granted a deferred judgment on the felony, giving him 12 months to complete alcohol treatment and maintain total sobriety, he didn't walk away completely free. To address the severe psychological impact on the victim, the court ordered Balalel to serve 10 days in county jail, calling the violent incident a severe warning shot across the bow.